Imagine firing up OpenAI's video tool Sora and instantly making a Pixar-style short or video with Spider-Man or Harry Potter or Mickey Mouse. It sounds like this could be the future of interactive fan fiction on the one hand, but on the other hand, here's the catch. Legally, that future is really questionable. It could land creators and OpenAI itself, especially, in hot water. Originally, OpenAI's plan was to let people use copyrighted characters in Sora unless the rights holders opted out. In other words, Disney would have to say no before you could stop people from making Mickey Mouse matchups. And in fact, they did say no, very clearly. But that opt-out system is legally questionable. Why? Because under US copyright law, characters like Spider-Man or the Batmobile are protected under copyright law just like the stories themselves. Making new videos with them is usually considered a derivative work, which requires the permission of the rights holder. This is especially true after some recent Supreme Court cases where courts are even less likely to view commercial mashups as fair use. So after some pushback on Friday, OpenAI finally shifted, or apparently shifted, towards more of an opt-in system, saying that rights holders will be able to grant permission and potentially even share in revenue. That's much safer legally than an opt-out model. And in one sense, it kind of mirrors what YouTube does with Content ID, in that rights holders would be able to block, track, or monetize different uploads. But it's different because AI systems generate content, not just host user-posted content. Moving to this opt-in is important. It's a way for OpenAI to potentially avoid lawsuits, but even with opt-in, risks don't vanish for OpenAI or its users. For example, there are trademark dilution claims risks. Fans could use Sora to say something vulgar or unflattering about a famous character or brand, and those owners could sue for delusion by tarnishment. There may also be limits to the licensing. Even if OpenAI cuts a deal with a studio, individual users may not have a sub-license that allows them to monetize or commercialize their creations using Sora. Just because you generated a Marvel short doesn't mean that you can go sell it or make a new movie about Mickey Mouse doing something. There may also be user confusion in the trademark context, where there may be a concern that the original studios are endorsing these new videos. So here's the bottom line. OpenAI's pivot from opt-out to opt-in is legally a much better choice. It makes Sora a lot more defensible, but creators should still remember that using iconic characters comes with strings attached. And those users are going to have to check to make sure that any deals that OpenAI strikes with those rights holders would potentially extend to users as well.
In addition to this commentary, my friend Paul over at MarketingAI Institute also wanted me to answer a few questions about this, so I'm going to do that now as well. He asked, what are my overall thoughts on OpenAI's approach of training on copyrighted material and then allowing the model by default to output things that may be copyrighted? That is a huge legal question right now, and we're waiting to see what courts are going to say. We've had courts come out mixed on that, and it's possible that some amount of training on lawfully obtained copyrighted works will be considered fair use, but there's no indication that OpenAI paid for access to these copyrighted works to engage in their training, so it would not comply under a Bartz versus Anthropic case standard, for example, but there may be other case standards under which that would be considered fair use. We'll have to wait to see how those court cases play out. Obviously, the safest option would be that if the opt-in from the rights holders includes not only a right to output, but a right to train on their materials. So that would be the clearest legal right way to go. Another question was, are individual users who choose to output copyrighted material using the model app at risk? So those users are potentially at risk if they don't comply with or if they're not subject to the terms of the license obtained from OpenAI. So, for example, if OpenAI allows users to generate the content using copyrighted characters that are opted in from the rights holders, but that right does not extend to a sub-license for the users to post that content, that would be problematic for the users. Typically, these arrangements would include a limited sub-license, but would not include a commercial license. So oftentimes, the rights holder and the application will strike a deal where users can, for example, post on social media, but cannot make their own for-profit movie using that material. I think that's the most likely scenario here with an opt-in or licensing model. So what do I think happens next? I think it's pretty clear that OpenAI has shifted towards more of this opt-in model because it's legally a lot safer. It's much, much safer, obviously, to negotiate upfront with rights holders and to make sure that, especially if a rights holder like Disney, for example, has said no, that you are not training on or especially outputting things that are based on their copyrighted works. So OpenAI needs to be careful here. They're facing legal hurdles on the legality of the training using that AI data that's not licensed in the first place. And then we also have concerns about the output. Most of these cases are saying that if you have generated outputs that infringe a copyright, that's not going to be fair use. So we'll have to wait and see, but I think that side of things, you really have to get licensed if you are an AI company.